Dear friends, this video is going to deal on the powers of the Supreme Court of India under Article 141 of the Indian Constitution to overrule its own ruling on several times and open to dynamic interpretation with a passage of time. This video is exclusively going to cover how the fundamental rights of the Indian Constitution under Part 3 of the Constitution have been curtailed or misused by the central jurisdiction at given point of time. What is important is that the rulings given by the Supreme Court of India is overruled by constitutional bench in the larger interest of ending the justice to not detrimental to the fundamental rights of the countrymen, but to enlarge the scope of the fundamental rights in a wider scale. Once the constitutional bench of the Supreme Court of India is given a ruling that is binding on all the courts in India, in all the territories and all the stakeholders and all the persons, including all the organs of the state, must abide by the final verdict and the interpretation given by the Supreme Court of India. Let us discuss about the judgments which were overruled by the Supreme Court in the larger interest of justice. We will discuss about A.K.Gopalan versus State of Madras in 1950. A.K.Gopalan was a school teacher and later he became a congressman and became the Kerala state president of the Kerala state, and had participated in various civil disobedience movement for the cause of Indian independence and had been arrested on various grounds. The point here is that the Supreme Court of India in A.K.Gopalan versus Madras State in 1950 has upheld that there is no necessity to disclose the reason for the arrest. It was just a curtailment of the fundamental rights of an individual under the Indian Constitution. What is important is that the judgment 4:2 majority decision gave limited meaning to fundamental rights and upheld preventive detention of a person without a disclosure of reasons or grounds to the arrested person. This is illegal and unconstitutional. Whereas in 1978, in Maneka Gandhi case, 7-member constitutional bench headed by Y.V. Chandrachud and also P.N. Bhagavati, who invented the tool of public interest litigation for the first time in the judicial history of India to protect the voice of the voiceless, spoke of the inviolability of fundamental rights that had been enshrined in the Indian Constitution to include the dignity of an individual in its ambit. The point here is that the right to life has been guaranteed in the Indian Constitution. It was upheld in the 1978 Maneka Gandhi case. And another case is that in 1967 itself, in Kolaknath case, the judgment has been delivered by 11 members bench, that is 6:5 ratio majority decision, has upheld that the fundamental rights of the Indian Constitution shall not be abrogated or abrogated by the Parliament by enactment of any law in the Constitution. The point that has been enshrined in the Kolaknath case was overruled by the then Indira Gandhi government. She was tried to overrule this case by appointing 13 members a constitutional bench headed under the Chief Justice of India. 13 members largest constitutional bench to override Kolaknath case, but the Kesananda Bharati case has upheld that the basic structure of the constitution cannot be abrogated even by amendment by the Parliament under 368 of the Indian Constitution, which included fundamental rights, rule of law, parliamentary form of government, that is secularism, federalism. All these should not be violated even by the Parliament by amending the Constitution in Parliament. Another point is that in ADM Jabalpur case, that is in 1976, the majority decision of 4:1 denied fundamental rights during the emergency period, that is during the internal emergency. All the fundamental rights that have been enshrined in the constitution would be curtailed, but it was overruled by 9-member constitutional bench of the Supreme Court of India in retired Justice K.S. Puttasamy had won the case, that is the right to life and the privacy of an individual and an intrinsic part of the Indian Constitution that cannot be violated even by making an amendment in the Constitution. Hence, from A.K.Gopalan to this Kesananda Bharati case, the fundamental rights have been curtailed by the then Congress government. Now the BJP central dispensation have been making a scathing attack on the fundamental rights, secularism, socialism, rule of law, federalism, all in their hands and powers to curtail all these things that have been enshrined in the Indian Constitution is so dangerous, whether it is Congress or BJP, or making laws against the will of the people, against the wishes of the people, against the forefathers of the Indian Constitution who made the Constitution for the betterment of the people of this country in all walks of life. This message must be taken to the citizens of this country in a wider way. Thank you so much.